In a time when government is steadily chipping away at religious freedom, at least in this case, the Supreme Court says that's too far. This is the Citizenlink Report. I'm Stuart Shepard, along with our judicial analyst, Bruce Hausknecht. Hi, Bruce.
Hi, Stuart.
Bruce, this was a significant win for churches, for Christian schools, for ministries of all kinds. Tell us what happened.
Well, it really was significant, and what happened was the Supreme Court heard a case that started in Michigan with a teacher at a Lutheran school who was called by her church. She had theological training. She taught religious classes and even led worship and prayer. But basically, the rest of her day was spent teaching secular subjects.
Right.
She contracted an illness and was missing a lot of work, and essentially they told her they had to hire someone else to fill the position. She said, no, you can't do that, I'm going to sue you. And they said, no, we have a procedure in our church for dispute resolution. And if you're not going to follow that, we're going to take away your call and essentially fire you.
Yeah.
She went to the EEOC, and together they sued the church for employment discrimination, specifically on disability. You know, since the 1960s, the first civil rights legislation, we've had a succession of discrimination statutes passed. Employment discrimination is one of those things. And so a lot of these cases have come up through the federal courts over the years. And we're arguing now about whether churches are exempted from those types of suits, and specifically which of their employees are exempted.
Yeah, and in this particular case, I mean, the details of it are a bit compelling. We might be drawn into the storyline here. Maybe she had a right to hang on to that job, but as often happens in these kind of cases, by the time it gets up to the appeals court, and particularly the Supreme Court, it's really no longer about the details of how it started. It's about the broader issue here, and in this case, it's how much does the Constitution limit what government can do, something we don't hear often enough.
Well, that's exactly right. And what has happened over the last 40 years or so of these federal courts have decided that there is a quote-unquote ministerial exception to these discrimination laws. But by the time it gets to the Supreme Court and Chief Justice Roberts' opinion, it's become a First Amendment case. And in fact, the First Amendment in the court's ideal trumps these non-discrimination statutes. And if I can quote from the opinion, I would quote what Chief Justice Roberts said on that. He says, "The interest of society in the enforcement of employment discrimination statutes is undoubtedly important, but so too is the interest of religious groups in choosing who will preach their beliefs, teach their faith, and carry out their mission. The First Amendment has struck the balance for us. The church must be free to choose those who will guide it on its way." And that's really the First Amendment Establishment Clause and Free Exercise Clause in a nutshell.
Summarize for me the argument that the Justice Department was making. It was a little out there, and that's something that the opinion really struck a hard rebuke toward.
Yeah, that's exactly right. In fact, it was more than a little out there. Essentially what the EEOC and the teacher who was suing, what they were alleging was that the religion clauses really don't protect the church or religious group in this situation. There might be some other First Amendment clauses that help churches just like the First Amendment might help a secular organization. Essentially making the religion clauses of the First Amendment meaningless. And Chief Justice Roberts had something to say about that as well. And I would quote him here. "The EEOC and the teacher who sued thus see no need and no basis for a special rule for ministers grounded in the religion clauses themselves. We find this position untenable. We cannot accept the remarkable view that the religion clauses have nothing to say about a religious organization's freedom to select its own ministers." So, in summary, that's the very polite Chief Justice Roberts' way of saying, we can't believe what you're arguing.
So when he says remarkable view, he's not saying, wow, that's really nice. He's saying, that's just not something that regular justice would support at all.
Well, yes, and even back during the oral arguments in October, Justice Kagan, who was appointed by the current president, who would be expected to be a liberal in herself and may be hostile to this church's claim, she found the EEOC's argument and quote, amazing, unquote, and not in a good way.
Typically, when we talk about Supreme Court opinions that deal with issues like this, or religious freedom or social issues, it always seems to strike a 5-4 split. We're always talking about the one justice that could have flipped one way or another. As you just mentioned, not this time.
Not this time. This is a 9-0 unanimous opinion on the First Amendment, as something probably unheard of in a very long while.
And that includes 2 people who were appointed by the administration.
That's correct. And usually considered to be 4 solid liberal votes on the Supreme Court, and especially in religious cases. We've had, disputes over Christmas creches and student religious clubs on campus, and those always turn out to be 5-4 decisions.
Yeah.
Not this time.
How will this play out? For those who are listening, if they're operating say a church camp or a pastor or administrative minister for a major congregation, or run a Christian bookstore or a Christian school, how does this play out in real life? How will this be applied?
Well, each case is going to stand on its own set of facts, but we do know some general principles based on what the Supreme Court has said. First, this applies to more than just churches. In the language of the Supreme Court, it applies to any religious community or religious group.
Okay.
Second, we know that it doesn't apply to a senior pastor or even the senior plus the associate pastor. This was a teacher who taught religion part-time in the school. And really what the court was saying is anyone who personifies the group's beliefs is going to be come under this rule. And that's going to bode well for religious groups of all kinds.
When you say it doesn't apply to a senior pastor or pastor, they were already pretty much considered in this protected class. This expands it out beyond them, is what you're saying.
That's correct.
Yeah. What about, say, a church camp or something? It is someone who's heading up the place, maybe an administrator, supervisor at camp, whatever you call it, whatever that title might be.
In all respect, in all due respect, it probably does. If they carry out religious functions, and I've been at religious church camps, and they do. They lead worship, they organize prayer, they do all kinds of things that have a religious value, a religious function to it. So yes, it could be in certain situations.
Very helpful. Hey, Bruce, thank you for keeping track of these things and helping us understand exactly how they play out in real life.
Sure, Stuart.
All right, and thank you for watching. We always appreciate hearing from you. You may always write to us at mail@citizenlink.com. We encourage you to pray for the members of the Supreme Court this week and to pray for their wisdom as they decide on cases like this that have a direct bearing on our religious freedom here in the United States of America. And remember, stand tall and be heard.